Hello, I'm attorney Matt Parker with the elder law firm of Marshall, Parker & Weber. Getting married later in life can be a rewarding experience. However, a marriage in your later years has issues that your marriage in your youth did not. For example, you likely have accumulated some savings and you may have children from an earlier marriage. An estate plan that balances the interest between the new spouse and your children from that prior marriage will have to be drafted. Here are some of the estate planning issues that you need to address if you're going to say I do in one of those silver marriages. First, you should probably address property issues in what's called a nuptial agreement. Nuptial agreements cover property issues that could arise in the event of a divorce or the death of one of the spouses. Usually the spouses in silver marriages keep their property separate from one another. They agree to leave their savings to their children in the event of the death of one of the spouses. Now, having an agreement regarding the residence is a good idea. If one spouse owns the residence, what rights will the surviving spouse have to reside when the owner dies? Set forth your right to reside in this nuptial agreement and then allow the proceeds from the sale of the home to pass to your children. Now, make sure your wills are updated. If you want to leave money or property to your new spouse, you're going to have to revise your will. Perhaps you want to leave money or property to them in a trust. That would protect your savings from being consumed by the surviving spouse and give a better chance of some of the inheritance passing on to your children. Now, powers of attorney may also need to be updated. When you marry, you may want to have your spouse make medical decisions for you if you become ill. If your children have a falling out with this second spouse, he or she may limit access to you if you become seriously ill. Now, your agent in the financial power of attorney will also have significant control over your assets, and they will have the right to change beneficiaries and even make gifts to themselves. Now, checks and balances can be put on these powers of attorney to limit the authority that you are giving your agent. Lastly, be aware of how your savings can be used to pay for someone's nursing home care. Let's say you're in a marriage where one spouse has sizable savings and the other spouse does not. If the spouse with limited assets enters a nursing home, their savings may run out quickly. Now, the medical assistance program does pay for the care of those who enter the nursing home, but the assets of both spouses will be counted to determine if you are eligible. Medical assistance determines eligibility without regard to these nuptial agreements. So your savings could be exposed to pay for your spouse's nursing home care even if you have a nuptial agreement. Now, if you want to learn more about estate planning with second marriages, do visit our website at paelderlaw.com.